Hey folks, Hal Shurtleff here with Camp Constitution, and we are at the Future of Christendom Conference in beautiful Reading, Pennsylvania, middle of October of 2018. And I am here with Colonel John Eidsmoe, who is a pastor, a constitutional attorney, and a retired colonel in the U.S. Army, I believe.
Air Force.
Air Force. And he's the author of many books, including one he's holding in his hand, Christianity and the Constitution, which I highly recommend. And I want to ask you, Colonel, what is your position on an Article 5 convention? And Article 5, of course, under the U.S. Constitution, the two ways to amend it. The second way that we've never had is through a convention. So what are your thoughts on that?
Perhaps we should quickly explain what the Article 5 convention idea is. As an alternate means of amending the Constitution, if 2/3 of the states through their legislatures petition for a new constitutional convention, then Congress calls the convention. They're calling it a convention of the states, but in fact the states don't call a convention, they merely apply for one. It is Congress that calls the convention. It'll be Congress that sets the rules for the convention, not the states. And there's not even a guarantee that the convention would follow the rules set by Congress. After all, the Constitutional Convention of 1787 went way beyond the mandate given it to by the Continental Congress.
And that was Judge Robert Bork's position, too, that even if Congress passed laws or rules guiding an Article 5 convention, that the delegates had no obligation to obey it.
Chief Justice Berger took that position. Professor Lawrence Tribe of Harvard, who I don't always agree with, but on
almost
this issue,
never.
He's taken the same position. And Justice Scalia has simply said that a new constitutional convention would be a terrible idea. He says it could be very dangerous. The thing is, even though we have been told that a convention could be limited to one issue, there is nothing in Article 5 that says that. In fact, Article 5 says Congress shall call a convention for the purpose of considering amendments, plural. And the idea that the Constitution or the convention could be going way beyond this to consider amendments not even proposed before, or possibly even a whole new draft of a constitution. All of these are possibilities that, in my opinion, a constitutional convention would be playing Russian roulette with the Constitution, if not constitutional suicide.
Do you think that members of Congress could possibly be delegates at a convention?
Nothing in Article 5 says they can.
That's right.
And if Congress were to set the rules for the convention, as they would have the authority to do, they could set the rule that only members of Congress could be delegates, or that any other rule they wanted to set. And here's another point, too, is that many of our conservative constitutional friends seem to assume that any convention like this would be run by constitutional conservatives. I see no guarantee of that. In fact, it's just as possible it could be run by media-orchestrated liberals, and it could be very destructive of the right to keep and bear arms, free exercise of religion, and many of the other rights that we hold sacred.
What's interesting is that your book was endorsed by Michael Farris of the Homeschool Legal Defense Association, I guess formally of that. He's no longer officially involved,
That's right.
Although he was the founder. You knew him personally.
Michael and I consider each other friends. We just simply disagree on this issue.
Was he in favor of an Article 5 back then, or did he even speak about it?
I never talked to him about the issue. In fact, I've never talked to him since about the issue.
And in your book, you do make reference to it in a negative light in that book.
Yes, but I don't know where Michael had stood previously. I just know that right now he and I are on opposite sides of this issue.
Now, what would you, so there's a lot of decent people that are involved in the Article 5 convention movement, and some not so decent, people like Cenk Uygur, for example. But the people that are involved with this group convention of states, they'll tell us that, well, what's our plan? What's your plan? And so what would you tell these folks to say, as opposed to what can we do to help restore constitutional government?
Well, some of the things that you're doing right now and that I'm doing, first of all, restore constitutional literacy to the nation. Make sure that people, particularly young people, understand what the Constitution says, what limits it places on government power, and inspire them to not vote for anybody that's going to violate those limits. Also, putting conservative judges and justices on our courts. First of all, you need to train them, and we have more Christian conservative law schools today than we have had in a long time. Oak Brook, where I teach, or Liberty, or Regent, or Trinity, or a number of schools like this. So constitutional education for lawyers and preparing them to be conservative judges and justices, those are some of the steps I would suggest. In addition to this, I believe that the Constitution gives the states the power to nullify various acts if those acts are passed by Congress, but if they're not right for your particular state. In other words, the power of nullification, the power to simply say that, okay, that federal law that was passed, that applies throughout the nation, but we're not going to apply it here in Pennsylvania.
Not in pursuance thereof, as the Constitution reads.
Exactly.
Yeah. And that's been done not too many times, but it was done to nullify the fugitive slave law.
That's right.
Back in
Some
the
of the same ones who would have said that southern states could not secede
Right.
had no hesitation applying the principle of nullification, which is related to secession, to the fugitive slave law, and rightly so.
And even recently, the Real ID Act. And there were a number of states that nullified that. And of course, some cities and states, which I disagree with, are, I think, illegally nullifying legitimate laws on immigration.
Well, I would agree with you on that, and I just say, as far as the sanctuary city issue, you know, the Ninth Circuit recently ruled against President Trump on that, and while I am not at all in sympathy with the sanctuary cities, I have to say that there is a point in the Ninth Circuit's ruling. They noted that Congress had appropriated these funds for the states and the cities and counties, but that the president had impounded them. And, you know, whenever you have a constitutional decision like this, it's sort of like a two-edged sword. And the question then is, how do you want this to be applied all across the board? Do we want a principle all across the board that the president can simply impound any expenditure that Congress has approved, and the president can simply say, no, it's not going to be spent that way? And if the money were cut off by another act of Congress, I'd feel very differently about it. But for the president to simply cut off an expenditure that Congress has approved and directed, I am not sure that's something that we really want in the long run.
Even though it was the wrong thing for the right reason, so
Exactly.
to speak, right?
Exactly.
So if people want to learn more about your ministry, get some of your books, how can they get a hold of you?
Well, you can contact me by email at eidsmoeja@juno.com, eidsmoeja @juno.com. Or you can go to the website of the Foundation for Moral Law, where I serve as senior counsel, and that is morallaw.org.
Okay, well, thank you so much, Colonel. It was a pleasure having you on.
Well, it's been a pleasure being here, and thank you for all you're doing.
Oh, thank you.
Educate people about the Constitution there at Camp Constitution.
All right, thank you. God bless.
You too.